I'm just not entirely sure that I'm prepared yet to say, yes, Jack Smith should go ahead and bring a superseding indictment that indicts all these other co-conspirators as well, because I think that it's the kind of thing where it just deserves a little bit more thought.
It's the Lawfare podcast, Trump Trials and Tribulations. I'm Benjamin Wittes, Lawfare Editor-in-Chief, with Anna Bauer, Lawfare Legal Fellow and Courts Correspondent, and Roger Parloff, Lawfare Senior Editor.
This week, Jenna Ellis made a plea agreement, and they seem to regard this as a pretty big breakthrough.
In a live recording on August 8th, we talked about Judge Chutkan setting a briefing schedule in Washington, D.C. We talked about how the state-level prosecutions of fake electors are proceeding. We talked about the bar disciplinary proceeding against Jeffrey Clark. And of course, we answered audience questions.
Viewers of the YouTube stream will notice that I'm wearing a Grateful Dead. I'm personally not that big of a fan, but they have a residency in Vegas. And so because I'm here, I thought, why not become a Deadhead for the weekend?
Hey, folks. Ben Wittes here from the ballroom at Mar-a-Lago. It is Trump's Trials and Tribulations, and it's going to be an interesting one today because not only is Roger Parloff joining us back from the Sconce studio in Washington, D.C., having left his days as a marquillard behind, returned to his natal shores, but Anna has built a new wing on her palatial mansion, and in a sign that the palatial mansion now transcends time and space, this room is in Las Vegas. Anna, explain to us how your mansion in Georgia can have a room in Las Vegas.
The palatial mansion has expanded, Ben. We have expanded because I'm here for a cybersecurity conference called DEF CON. However, this new wing is named the Deadhead wing of the palatial mansion because viewers of the YouTube stream and who have joined us here in the Zoom will notice that I'm wearing a Grateful Dead t-shirt. The Grateful Dead, one of the great jam bands. I'm personally not that big of a fan, but they have a residency in Vegas. And so because I'm here for this conference, I thought, why not become a Deadhead for the weekend? And tonight I'm going to see this concert at the Sphere. So it should be a good time. But in case anyone is wondering why I'm wearing a Grateful Dead shirt, that is why.
There we go. And I, of course, am wearing a dog shirt, and you know why. But I will say we want to have one other program note about Anna's presence in Las Vegas. For those of you who know anything about DEF CON, the conference that she's at, you know that walking into that facility is considered consent to be hacked. And as a result, Anna is not using any conference Wi-Fi to connect with this live stream. She's using her personal hotspot. So if her connection is a little iffy today, we're just going to roll with that. It's better than the fly last week. But it is really actually an issue when you're at DEF CON. People hack you, and you can't have that during a live stream. So with that, let's turn to the Trump Trials and Tribulations, because Trump has been, if not trialing, certainly tribulating over the last week. And we've got a bunch of developments that we're going to talk about. The first of them is the one we were waiting for last week, but didn't happen. It is Judge Chutkan setting a briefing schedule and on the remand, receiving the mandate. She got the mandate from heaven of heaven. She is set a briefing schedule, and she's issued some rulings. So Roger, give us an update on Judge Chutkan's moves over the last week?
Yeah, I think the case got back to her on August 2nd. And so on August 3rd, she jumped into action. The main event is scheduling this, eventually a hearing on what to do next about the immunity ruling. She's asked the parties to submit a joint memorandum by tomorrow, August 9th. And that will probably not be very joint. I imagine they'll have different paths, the Trump and the prosecutors that to recommend. So each side will recommend the path forward. And then there will be a hearing next Friday, the 16th. That's the big thing. She also quickly, I think in the same order, actually, dismissed without prejudice a motion to dismiss that had been filed back in October based on statutory issues, meaning the argument that each of the four counts, some element of each of the four counts was allegedly not alleged. And but she just dismissed that without prejudice. Basically, she will revisit it after the immunity stuff. So everyone understands it's likely that some stuff may be dropping out of the case as a result of the immunity rulings. In fact, it's certain that some stuff will be. And then she'll revisit it. And then the other thing was also on later in August 3rd, she dismissed a motion to dismiss based on selective and vindictive prosecution. This was a motion that versions of which Trump filed in both Florida and D.C. The Florida one was never ruled on. The D.C. one, she dismissed in a refreshingly just the facts, ma'am, sort of way. It was short. There was no hearing. It was 16 pages. It was, very poker-faced, no snide comments toward one side or the other, and no apologies for ruling against Trump. And
you mean she didn't spend the first 15 pages saying that all of Trump's arguments were correct, and then in one sentence at the end say, but precedent requires that I deny this?
There was no flattery for some reason. I don't know why, but it was missing from her. So this was a pretty different thing than we were used to seeing. But anyway, we are back in DC.
And for those, I don't think you mentioned, what are the dates of the that are upcoming in DC? August
9th, which is in real time tomorrow. And
that's for the joint status report, right?
That's right. The joint status report.
Can we call it the not so joint status report?
Yeah, that's a good. And a week from then, August 16th, we have a hearing and to discuss it further.
And so I'm curious for both of your guesses on this. What are we expecting from the joint, not so joint status report? I could see normally in one of these things, you say the parties agree on the following and they disagree on the following. Here's the prosecution's position. Here's the defense's position. I think here you can probably imagine a section. The parties agree that under the Supreme Court's ruling, these various allegations have to drop out, and then they disagree on everything else. Like, how are you imagining it looking? Roger first and then Anna.
Well, they will differ both in terms of timing, obviously. I think Trump will ask for whatever hearing goes forward. It should be after the election, and he will say that that's required by the 60-day rule or the 90-day rule, which the special counsel has already said is inapplicable. But the main thing will be what will this hearing look like? Will it have any evidentiary aspect to it, which I'm sure Trump will object to entirely. Well, I shouldn't say that. I assume he'll object to entirely. But I don't know if that's what the special counsel will propose either, or whether it will be more like um, the lawyers discussing, here's the nature of our witness list to the extent we can disclose it. I mean, you sort of have to, you don't like to disclose your witness list now, because of harassment issues
Not to mention, you don't want people to testify more often than they have to on the same set of facts, because some tiny little incremental distinction between what they say time X and time Y becomes basis for impeachment.
Yeah. On the other hand, there's been speculation that maybe they would want to get as many facts out before the election as they could. I don't know if the special counsel will really operate that way. But apparently, I mean, certainly you will need to go through the indictment and say, is this immune with or not? And if it is an official act that's for which he's immune and he can't be held liable for it, can you introduce it as evidence nonetheless for some purpose? But I would think you would also have to even go beyond that. The hint in the opinion, Supreme Court opinion, was that he wanted to know more than just what was in the indictment, and the indictment's quite long. He wanted to know, like, if you're going to use anything from the January 6th speech at the ellipse, Chief Justice Roberts seemed to want to know more about the rest of the speech. So you might need to get into very picky detail about all of the evidence at this stage, which is just, I mean, it's really hard to imagine.
What do you think of that, Anna? What are you expecting it to look like?
I think that I agree with Roger that it's really hard to imagine. I think that we're going to see a number of disagreements between the parties about a variety of things. One being, as Roger alluded to, this question of to what extent there should be an evidentiary hearing and exactly what the scope would be of that hearing. I think it's unclear to me as well, just the order of operations here, which I've talked about before. Is if she does have an evidentiary hearing, does she first have an evidentiary hearing that is just on the question of sorting out the official from the unofficial conduct? And then does she later hold a separate hearing that is on whether or not, if there is official conduct, the presumption can be overcome, that conduct is immune? I think that there's a lot of questions too about, as Roger said, to what extent, again, you actually need to have any sort of additional facts beyond the allegations in the indictment. And then there's this question of how far at this stage does Judge Chutkan need to go beyond just the indictment, in the sense that she is, because of that section 3C of the opinion, which says even if you have a case that is based on unofficial acts that aren't, or acts that, aren't immunized, then you still can't introduce evidence of official acts in that prosecution. So to what extent does she, at the very outset right now, need to just have the special counsel list everything that it might want to introduce as evidence? Because from a judicial efficiency perspective, it might just make more sense to have one big mega hearing on sorting out what's official and what's unofficial in terms of all of the evidence, not just what's in the indictment.
Yeah, I think that's right. I think what you're going to see tomorrow is the parties agreeing on a certain set of things that have to drop out. And those will be the ones that involve intra-executive branch firing decisions. And then the government will take the blanket position that everything else fits into one of three categories: either personal personal conduct that isn't immunized. Second is footnote 3 material, a la what Anna just referred to. And 3 is stuff that is official conduct, but that would cause no burden on the executive branch institutionally or on the exercise of executive power to have not be treated as immune, and therefore the immunity is overcome. And that'll be their blanket position regarding a huge range of material. And then the defense will take the view, we agree on the stuff that they agree to drop. Everything else, they'll acknowledge a few things are personal. They won't, but they'll make a very large volume of stuff that will contend is official, and nothing that's official can be overcome, which is actually potentially consistent with the opinion. And so I think they will then leave it to her to decide how to disaggregate those. And I think as an initial matter, she will just have a hearing on it and hear probably ways forward. But I think we're in for a long slog here in the district court before it moves further. And I don't think anybody should expect a trial date to be anytime soon. Roger?
Yeah, and of course, the way I read the opinion, however she does rule, that itself would probably be the subject of an interlocutory appeal.
That's absolutely correct.
Yeah. And then there's one other thing. I was going to sort of go off into a different subject it's still the DC case, but I was interested what Ben and Anna thought. Professor Randy Eliason also was recommending that maybe at this point the prosecutors should have a superseding indictment and bring in the 6 co-conspirators who weren't included initially, or at least 5 of them, because the idea apparently of not including them was to streamline the case, and that failed. This is not going to, there's not going to be a case before the election. So maybe we should have a superseding indictment. That's his suggestion.
What do you think of that, Anna?
Well, I actually am curious to hear your thoughts first. I don't quite know yet what I think about it.
All right. So first of all, should there be a superseding indictment? Yes. And the reason she needs to do a superseding indictment, or he needs to do a superseding indictment, rather, is that there's a whole bunch of material in there, like, for example, everything about Trump tweets or something, or Trump public statements that are potentially footnote 3 material, which means they're official, but there's a public record of the act, right? And that can't be charged, depending on whether it's in totally immune or in presumptive immunity land, but it can be evidence, assuming that Anna and I are reading footnote 3 correctly, which God only knows if we are. That stuff makes more sense to be evidence outside the indictment than it does to be inside the indictment. In addition, there is almost certainly you're going to want to craft the story in the indictment differently in order to highlight things that are in the personal category, not in the immune category, and highlight things that are in category 2 that, maybe you can overcome the immunity or footnote 3 material rather than that is in category 1. And so, which are going to drop out anyway. So you're going to want to retell this story. And I think you may want to do it in a more streamlined fashion. I think in light of, you wouldn't have written the indictment this way if you knew the Supreme Court was going to take this position. And the normal way of handling that would be to file a superseding indictment. So I think that's very likely and probably very advisable. The second question is, should you now include the other rogues. And I think there's honestly a good argument on both sides of this. The interest of justice definitely support indicting these people, some of whom, they're guilty. If this indictment is true, they are guilty of serious crimes. And I do think the main reason for not having named them in the first instance was that it was going to slow things down. And now that is not a factor anymore. There is also another reason for doing it, which is that if Trump is really immune and that prevents the prosecution, prosecuting all the people around him, a kind of all the president's men indictment, has a different deterrent effect, right? Which is you can't deter someone from behaving like Trump because of the immunity stuff, but you can prevent people like Meadows and Giuliani from being quick to help him. And that is a factor that, in my judgment, counsels for naming the unindicted co-conspirators. The factor in the other direction is added complexity. And, Georgia has not benefited by the added complexity. And, of course, they named 18 other people, right? This is a little bit more disciplined than that. But there's something to be said for the keep it simple principle if you're trying to get this done in any time, more expeditiously than the 9/11 case. Anna, your thoughts?
Yeah, so to be clear, the reason that I was hesitant is that that last point, the added complexity, and I would want to think a little bit more about some of the procedural aspects of if you do a superseding indictment that has a number of added co-conspirators, how there might be some, there's just weird kind of rules that could affect things like you start slowing things down in a number of ways. And at this point, yes, things can't really get more slowed down. So I guess there is a kind of element of why not. But there just are some weird things that I would need to think about a little bit more in terms of what it would mean to add a number of co-conspirators when the case is already this far along. And then also, although I guess it's not that far along because
the case isn't that far
since December. But I would also add, though, too, that even if you do a superseding indictment where all of these co-conspirators are added, it would be the same situation as it was as it is in the Georgia case, in which it's almost certain that Trump needs to be severed in terms of actually trying all of these people, because you're going to have unique issues that affect Trump related to immunity that I think, and the Supreme Court might later say that I'm wrong about this, but I think that those immunity issues do not affect the individuals who are the co-conspirators.
That almost has to be right. There's got to be a lot of the evidence that is not admissible against Trump, presumably is admissible against the others.
Right. And I think that, people have asked before about the Nixon case. And I think that if Nixon is still good law, then Nixon seems to counsel that the co-conspirators could be tried with the evidence that might be inadmissible as against Trump. But the point is just that all of these things raise a number of additional hurdles and complexities, as you mentioned, Ben, that I'm just not entirely sure that I'm prepared yet to say, yes, Jack Smith should go ahead and bring a superseding indictment that indicts all these other co-conspirators as well, because I think that it's the kind of thing where it just deserves a little bit more thought.
All right. So quick, cool question for you both. How many pages is the not so joint status report going to be? It's going to come in tomorrow evening, and it's going to be, Anna Bauer, how many pages?
Oh God, did she have limits that were set on the, I don't know, because she might have set a page limit and I just didn't notice it. And she also has, I'm sure, as Judge Judge Cannon is very strict about page limits. I haven't seen any filings, though, to file something in excess, but since it's a joint status report, maybe there's a different rule in Judge Chutkan's courtroom. I'm not entirely sure, and I think maybe Roger might have more information on that than I would.
I don't know about a page limit because it's a status report. I mean, I wasn't expecting for each party to have their color-coded indictments, ready. I thought it was more going to be a scheduling thing, like here's the briefing schedule that you should do, or here's the path. Much more broad brush at this stage, still, certainly from Trump. So I might be wrong. I don't expect. Yeah,
Not expecting a long document.
No, and not a very nuts and boltsy thing yet. More like, we will need a hearing. We will need a briefing. And this is how we proceed. Here's the schedule.
Yeah, and they'll probably do like they've done when they've had all these, proposed schedule battles in Southern District of Florida. They're each doing kind of tables of what the defense wants and tables of what the prosecution wants. And then they kind of say, we agree on this, but we disagree on that. And so it's going to be less probably legal argument, although I would suspect that there will be some of that because they're making their initial case, right, for whether or not, especially on the question of an evidentiary hearing. And it seems to be the case that Trump's team is going to say that doesn't need to be one, or it needs to be very minimal. So I think we will see at least a little bit maybe of legal argumentation or request for argumentation on that specific issue. But I agree with Roger that I don't think it's going to be like, 100-page brief or something. I think it'll be maybe 40 pages or less. But Ben, it seems like
I'm going to totally outflank you both.
Okay.
I think it's going to be a much more substantial document. I think it's going to articulate where the parties are in agreement and on disagreement, not just on scheduling, but on the substance of how to proceed. And I think it's going to contain a sketch of each party's position, and it's going to be a substantial document, and we're going to have fun with it tomorrow evening. It's going to be like one of those Friday evening document drop situations, and the whole press corps is going to flip out. It's going to be 48 pages. All right, let's move on to New York, because something happened in New York that caused a change. The change amounts to 10 days, which is like when we moved from the Gregorian calendar to the current calendar. 10 days dropped away. Well, Justice Merchan just added 10 days to the calendar. Anna, what the heck's going on?
Right. So Justice Merchan has initially set a deadline for himself regarding the post-trial immunity motion in which Trump is trying to vacate his conviction and get the indictment tossed out on immunity grounds. We've talked on previous episodes about the briefing in that on that motion, and that has now wrapped up. And initially, Justice Merchan said that he was going to rule by, I believe it was September 9th. Is that correct, Roger?
Originally September 6th.
Oh, excuse me, September 6th. And then now he has changed that. He's pushed it back to September 16th. That is the same week that Trump is scheduled to be sentenced, if, as Justice Merchan said, if necessary, because of course he won't be sentenced if Justice Merchan ultimately determines that the case should be thrown out. But so now we won't get a ruling on that immunity motion until September 16th, 10 days after Justice Merchan originally promised that he would rule. And then September 18th is still the scheduled sentencing date for Trump. So that has not been pushed back. And then Justice Merchan also promised that he would rule on Trump's third motion for recusal before that sentencing date as well. That is supposed to come next week, I believe. So lots of action in the next week in terms of Judge Chutkan in Judge Chutkan's courtroom, and then also from Justice Merchan. But I suspect that recusal motion is not going anywhere, as it has not gone in the past two times that Trump has tried to have Justice Merchan recuse.
Yeah, so I think the recusal motion is uninteresting, but the change in the schedule is not uninteresting. And I think we should speculate recklessly about what adding 10 days to the calendar does here. Because let me argue it both ways, and then you guys decide which way is right. One is he knows he's throwing out the case. All he's doing is writing it. And so if you do that, you don't need any more time on the sentencing, because you're the judge, there's not going to be a sentencing. And so you give yourself a little extra time to write a pretty opinion, and then the case goes away. Or not goes away, but needs to be retried. Possibility number two, he's going ahead with sentencing on the 18th. He knows that. And he's giving himself time because he wants to write. This is the opinion that he's going to write that's going to have to survive federal court scrutiny, most certainly. And so he's going to write as good, solid an opinion as he can. And he's going to give himself the extra 10 days to do that. Third possibility is he actually doesn't know what he's going to do yet, and he's giving himself time to figure it out. What do you think? Which scenario are we in?
There's also another possibility, which is that Justice Merchan saw that Ben Wittes and Anna Bauer wrote a footnote 3-piece, and he saw that Roger Parloff wrote an analysis of what he should do.
That's right. And the combined word total of the two articles is like 20,000 words. So he's like, I got to give myself time to read this shit.
Right. That's what I think happened personally, is that he's just reading the Lawfare articles, and that's why he needed 10 extra days.
Yeah, I think it's clearly the latter.
All right. On that not at all self-regarding note, let us turn to the state of Arizona, which we are turning to not because Anna Bauer is right next door in Nevada, but because the state of Arizona, lest you forget, has criminal proceedings involving January 6th. And there's been some action, including a plea deal given involving longtime friend of the show, Jenna Ellis. Roger, bring us up to date on the state of affairs in Arizona.
Yeah. So you remember, I think there are now five states that have brought indictments relating to the election. And I think involving 51 defendants besides Trump, Trump being charged in Georgia only. And Arizona is one. They had charged 18 people. And this week, Jenna Ellis, who was one of them, made a plea agreement. And it will allow her, all 9 charges against her will be dropped. But she must cooperate fully and testify against at trial. And if they don't like the way she's following up on this agreement, they can reestablish the charges. They seem to regard this as a pretty big breakthrough. Remember, this case had, I think it has 11 false electors, and the others are Jenna Ellis, Rudy Giuliani, Mark Meadows, Boris Epstein, John Eastman, Christina Bobb, and Mike Roman. Also this week, I think the next day, one of the false electors, Lorraine Pellegrino, pled guilty to a lesser offense, one count, recording a false document. The charges here are conspiracy, fraudulent schemes, and forgery. So that was a second development. A third development was sort of a weird one. There's a number of the defendants have moved essentially to dismiss for selective and vindictive prosecution. And so in responding to that, saying, we weren't being vindictive or selective, we were very fair, the prosecutor, and it's being brought ultimately by the state attorney general, Chris Mays, pointed out some of the instructions that were given to the jury. And one of them was that apparently the assistant bringing the case, Nicholas Klingerman, basically instructed the jurors that he urged them not to indict Trump. He also urged them not to indict 28 state legislators or legislators-elect in some cases, who had purported to pass a false, something called a resolution, but it wasn't really a resolution, and it accompanied the false elector slates that were sent to the president of the Senate and the archives and so on. And so those were sort of interesting little details. There was another little detail in there about Christina Bobb, who is a defendant here. If you remember, she has a cameo in the Florida case. Remember on June 3rd, Evan Corcoran was turning over the 38 documents in response to a subpoena at Mar-a-Lago, and they needed somebody to sign to say they were the custodian of records and to say that's all there is. A diligent search has been performed. That's all the responsive documents. And apparently the day before, apparently Evan Corcoran did not want to do this. I mean, we don't. I'm speculating, but it looks like Boris Epstein might have been the one who called up Christina Bobb and said, "Are you available? We have a little task for you." And she volunteered. And there's a little detail in this case. Apparently, she wrote a Twitter direct message on January 6th, and unfortunately, it doesn't say the exact time frame of the message, but it says, "I'm here with Rudy (brackets Giuliani). We're safe. It is not over. Working lots, but nothing has been certified. We definitely need pray." And then the next sentence is probably disputed. "The fact that the votes weren't counted is good." Now, but that's at least the way the government reads it. The word weren't, the N is not there, so it's were space T counted. But anyway, that's a little detail that's sort of interesting.
All right. The other area where we had movement was in the District of Columbia court system, where attorney Jeffrey Clark was not disbarred, which I gotta say surprised the heck out of me. Anna, have you read this opinion, and what do you make of it?
Yeah, so this is the we talked about this a little bit in the during the spring on Trump Trials and Tribulations, because what happened is that Jeffrey Clark had a trial before a hearing committee of the DC bar. Bar investigators had claimed that he violated the rules of professional responsibility that lawyers who are part of the DC bar are obliged to follow. They charged him with attempted serious interference with the administration of justice and attempted dishonesty in violation of the rules of professional conduct. There was a trial, and when it concluded, the hearing committee announced its preliminary finding, which was that Clark had violated at least one of the rules of professional conduct. At the time, it was unclear if they meant that he violated both or just one of those charges, but they did find that he had engaged in professional or in a violation of those professional rules. The disciplinary investigators saw a sanction, which was disbarment. And of course, Clark's team argued against disbarment, but this 216-page report that the hearing committee just issued earlier this week explains in detail its findings and then the sanction. And so on the first part, and keep in mind what conduct this is for. It's exactly or very much overlaps with what Clark is charged for in Fulton County. It relates to the proof of concept letter or the draft letter that Clark wrote when he was a member of the Department of Justice. That letter was meant to be sent initially to the Georgia members of the Georgia state legislature and Georgia government officials. And it claimed that the Justice Department had identified concerns with the results of the 2020 election. In Fulton County, he is charged as a result of trying to attempt to influence his superiors to get them to send this letter. He's charged with attempted false statements. Here, under the DC Bar professional rules, it was attempted dishonesty. So very similar kind of overlap there in terms of the conduct for which he is charged in Georgia. And then here, and the DC hearing committee found that the counsel showed that he did engage in attempted dishonesty. But there's a lot of nuance that they find here in terms of to what extent Clark is culpable for that attempted dishonesty. They seem to think that they note, for example, that witnesses testified that Clark did seem to sincerely believe that there were issues with the election. However, they then go on to say, but despite his sincere belief, he was reckless in terms of what his superiors were telling him about investigations that DOJ had done related to the election. And his sincere beliefs were not objectively reasonable. So they were able to ultimately say that he did engage in attempted dishonesty due to that extraordinary recklessness with which he, went about trying to convince people to send this draft letter. And they found that he did not, however, engage in attempted serious interference with the administration of justice. The reason being that the hearing committee found that essentially what counsel was arguing did not, as a legal matter, amount to a process that has been identified in the case law that is actually attempted to be interfered with. So what I mean by that is that they're basically saying that you have to have some kind of judicial process or something that is identifiable that someone is actually going to have some kind of impact on. And here, because it's a draft letter that would have been sent to state legislators, there's just no identifiable process that really kind of amounts to something like a judicial process that Clark was attempting to interfere with. So because that element was absent, they found that his conduct did not amount to attempted serious interference in the administration of justice. They then proceeded to talk about the sanctions. Again, bar counsel tried to say that disbarment was the appropriate sanction here. Clark's counsel said basically, we think that they are being overly emotional about the way they're presenting the seriousness of this conduct. Because bar counsel said that Clark's conduct was, the worst since the Civil War and the biggest threat to democracy since that time. And actually, surprisingly, the hearing committee actually seemed to agree with that and said that they basically agreed that that was an overly emotional kind of comparison to use on insofar as the disciplinary council compared Clark's conduct to, the greatest threat to democracy since the Civil War, that kind of thing. They said that Clark was not as culpable as people like Giuliani and Eastman. And they again, pointed to the fact that there was witness testimony in which Clark seemed to be sincere about his beliefs. And so for those reasons, and then also there's certain legal reasons rather than factual reasons that they discuss here. One being that under the case law, what bar counsel is supposed to do is point to comparable sanctions for comparable conduct. And here, because there wasn't really any comparable conduct, I believe this was the first time that there was a charge of this type.
This happens so rarely in American history that it's very hard to find comps.
So there wasn't any comparable conduct or sanctions for comparable conduct that's
sort of like the Jeffrey Dahmer defense. No one's ever eaten this many people before. How can you got to go easy on me. How was I to know that the 17th person?
Right. And there's this idea, I suppose, according to the hearing committee, in which if there is nothing to compare it to, then the committee's supposed to go with the most de minimis or kind of the most minimal sanction that they feel appropriate. Also taking into account of all the other factors like the seriousness of the misconduct, all of that. And so with all of that said, they ultimately landed on a recommendation for a 2-year suspension with also the requirement that if Clark is going to have good standing again, he has to kind of go through like basically like a fitness kind of a test, basically, before he can get his bar license back. So that is what they landed on. The next steps, I believe there's a period of time in which Clark can file objections and appeal. It goes to the board of the DC bar, which is because there's all these different steps. There's first the hearing committee. They have submitted this report and recommendation. This is not a final binding decision. It then goes to the board, and there will be briefing, there will be oral argument if Clark requests it. And so then they can either accept or reject or modify the hearing committee's suggestion. So,
all right. So I have 3 things to say about this. The first involves the charge attempted dishonesty. Now, there are many attempts. There are many things that you can do wrong. And we have an attempt charge so that you don't actually have to complete the act to be guilty. You can be guilty merely of attempting it, attempted robbery, attempted murder, right? Like the idea is that you're morally accountable to the law merely for trying to do it. Now, how do you fail at dishonesty? I mean, you asked me if I killed the guy. I meant to say no, but it came out yes. So that's attempted dishonesty, even though the result was honesty. What do they mean, attempted dishonesty?
Well, I mean, you're making the argument that like during the trial, his counsel often made. And Ben, I will say that this is basically what he's charged with in Fulton County, except for beyond the racketeering charge. It's a combination of the criminal attempt statute in Georgia and then false statements in writing. So
right, but a false statements in writing is a little bit different from dishonesty. Dishonesty is a state of mind and a behavior. It's not, there's no elements of it, right? To be like it makes it sound like he attempted dishonesty, but he didn't accomplish it. All right, that's thing number one. Thing number two, let's talk about this he sincerely believed thing. This guy is, he sincerely believed something that was not true. He used or tried to use the power of the United States Department of Justice to coax, compel, bully the state of Georgia into taking action based on his objectively false belief that he sincerely believed. Why is that exculpatory?
I mean,
just like, help me out with that. Like, I sincerely believed the person on the street was a raging bull elephant, so I stabbed him to death. I mean, okay, maybe you can say, like, at some point it kind of bleeds into a diminished capacity / insanity defense, which, by the way, do not work in bar proceedings, since you can't go to the bar and say, please let me represent clients, I'm insane. But why is it exculpatory if he sincerely believed? And why are they, I mean, this is doesn't sound serious, but it's serious. Are they sending a message to, pardon me, lying sacks of shit attorneys? Just get high on your own supply. We'll go easier on you.
I mean, that is certainly seems to be one argument. It is a bit confusing to me because they say over and over again in this report, he was sincere in his beliefs. He really did. Clark, while misguided, was sincere in his belief.
Makes it worse.
He was, and I mean, it's. And yes, there was witness testimony to that effect. And there's a number of different ways in which he could have been sincere, right? Like, one is that they say at one point he was sincere about whether or not it was appropriate to send the letter. But then there's also the separate question of, was he sincere about his views about the election? Then there's the question of, was he sincere about the representation made in the draft letter that the Justice Department had identified concerns about the election? And the hearing committee does go on to say that, he discussed what the Justice Department knew and had learned with his superiors. His superiors tried to dissuade him from this course of action and told him that it was inappropriate. And yet he, even after that meeting, I think they mentioned that there's 70 minutes, even after he was told that sending the letter would be appropriate, he was still pushing to do it. There's no evidence of how, whether or not he considered how the Justice Department's role fits with the sending of this letter. So there's a lot of tension here where the bar hearing committee is saying, well, on the one hand, he was sincere, but on the other hand, he was very reckless in terms of, all this other stuff. And he ultimately was objectively not reasonable.
Memo to the DC bar. Fanaticism is not a defense. Or at least it shouldn't be. Please go easy on me. I was a fanatic. I genuinely believed all these things that are objectively untrue, and I zealously pursued them in the face of all the evidence. That is not the mark of a good lawyer. All right. Let's move on to the next item of business. Roger, do we have anything to talk about regarding the 11th Circuit and Judge Cannon?
I don't think so. I think nothing has changed. I guess the government's brief will be due August 27th. This is in the appeal of the dismissal for on the theory that the special counsel wasn't properly appointed. And then we'll have 30 days for the special counsel to respond, 21 days for the reply. So the briefing should be complete by October 17th. And then we don't know when the oral argument will be. So that's where that is for now.
All right. And we're going to have to wait for Anna to come back before we can ask our Fulton County updates question. So in the meantime, let's go to audience questions.
I could mention something about Fisher.
Sure, please.
Just briefly, Fisher is the case that the Supreme Court heard about the statute corrupt obstruction of an official proceeding, 18 U.S.C. 1512C2. And this is a very important statute in the what we call the blue-collar January 6th cases. About 355 people have been charged with it. The Supreme Court narrowed the meaning quite a bit to 6-3. And good to see you back with us. So we're about to find out if the government can, nevertheless, the government has claimed that it thinks it can still use it in January 6th cases. The new holding is that the government, this is the corrupt obstruction of an official proceeding, and you can't prove it anymore by just showing that somebody obstructed an official proceeding. And now the government must establish that the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or other things used in the proceeding or attempted to do so. This, by the way, is also, there are 2 counts of this or of conspiring to do this against Trump in the DC case. That's one reason it's also important. So anyway, the government has a theory that it can still use this in January 6th cases because of the ballots, the electoral slates that were being counted on January 6th, that maybe there was an obstruction of the availability of those. But it hasn't really developed that. And so the case went back yesterday to Carl Nichols, U.S. District Judge Carl Nichols. He's the one that started all this because he's the one D.C. judge who rejected the Department of Justice understanding of what this statute meant and read it much more narrowly. 15 other D.C. judges at least had viewed it the way the DOJ did. But the Supreme Court 6-3 agreed with Carl Nichols. So now it goes back to Nichols, and the DOJ can either try to convince Nichols that there's this backup theory. In reality, Nichols has already basically rejected this backup theory the first time around. So it's not a very good likelihood that he will accept it. Also, there's been a couple other cases in front of Judge Nichols in the last month that raised 1512C2. And in both cases, the DOJ simply ended up dropping it. In one, it was part of a guilty plea. In the other, they were able to sort of go back. They had started talking to police officers and looking at film, and they realized the guy had done more than they thought initially he had, and they charged him with impeding police officers. But anyway, we're about to find out how sharply the Supreme Court ruling does cut. I think the answer is probably pretty sharply.
All right. Before we go to audience questions, Anna, do we have any Fulton County updates?
Not at this time. The appeal is still pending, Ben.
All right. Josh Knight asks, is there any word on the E. Jean Carroll cases? I have not heard any. Have either of you heard of any action in any of the E. Jean Carroll cases?
Oh gosh, I had an answer on this like a week or two ago, and now it is. I am not able to answer it as well as I was then, but I believe that at least the last time I checked the docket, which was a few weeks ago, there were still appeal issue. Like there was a notice of appeal that had been filed in one of the appeals, but there wasn't any substantive action yet that had happened. So to whoever asked that question, I will check. And then when we discuss next week, have an update for you. Sorry about that.
All right. Next question, which is an Anna Bauer special. Is there a risk that the prosecution's actions in the Young Slime Life trial, which we here call the YLS trial, not the YSL trial, could further taint the Georgia AG's office, that's the DA's office, in a way that will impact Georgia v. Trump?
Yes. So first, very important not to confuse the Young Slime Life case with the old Slime Life case, as Ben calls.
Or the Yale Law School case.
But yes, so I look, I think that that's a really important question. In a legal sense, the answer is no. These are different prosecution teams. There's not overlap between the prosecution team, other than that all of them being prosecutors in the Fulton County District Attorney's Office and working under Fani Willis. But in terms of public perceptions, I certainly think that, especially after what happened in the Trump case, with respect to the disqualification issue and those hearings, and then also now the way that people have been paying attention to the YSL case, I think that it in a public perception issue, that case has been a really, really, I think, embarrassing case for the Fulton County District Attorney's Office. If you're someone who's been following that case, I mean, it's a disaster. It went off the rails a long time ago, and it continues to go very poorly for the District Attorney's Office. And I think that the District Attorney has sustained a lot of criticism. And I think rightly so, if you know the details of that case, which I don't think we need to get too much into right now. But I do think that it is something that raises some issues and more questions for the District Attorney's Office, but nothing in terms of the actual legal impact.
All right, Michael, the floor is yours. It looks like you have two questions.
Sure. So first one, should Merrick Garland consider folding the special counsel's office back into Main Justice now that the condition that led him to appoint Smith in the first place is no longer the case, that being Joe Biden's not prosecuting his political opponent anymore?
Roger, Anna, do you guys have thoughts on this, or should I take it?
It's a pretty funny suggestion. Let's moot out this issue. We'll simply give this. You were all upset that it wasn't Merrick Garland handling it. We'll give it to Merrick Garland. I don't know. That's an interesting argument. I sort of feel like it's the same administration. She's close enough to Biden that there's still an issue, but that's an interesting argument.
So I will say, no, they shouldn't do it. And more importantly than what I think they should do, they will not do it. And there's two reasons for that. The first is that there are a number of ways they could cure this problem that she's identified. The smoother way, by the way, would not be to change Jack Smith's status. It would just be to have the case re-indicted by the U.S. Attorney's Office in Florida. But if you do that, you leave her decision on the books and it remains as precedent. And I think there will be a strong desire on the part of the Justice Department to have it reversed or vacated. So that's reason number one. Reason number two, which is related, is that the Justice Department doesn't want to acknowledge that there is some doubt as to the Attorney General's authority to appoint an independent prosecutor. And that's actually, if you think about how often that's been done over the last 40 plus years, that's an important institutional authority that they don't want to live under a cloud with. And so I don't think there's any chance that will happen. I think they're going to live or die, and I'm sure they think live under the 11th Circuit's supervision of this, with the caveat that the Supreme Court and Justice Thomas is waiting in the wings. Your second question, sir.
Sure. So it seems likely to me that Trump may want to introduce official acts evidence in his defense, maybe most obviously in Florida, but in either case. So how would that be affected by the evidentiary component of US v. Trump? Does that open the door to the US introducing what would otherwise be an inadmissible official acts evidence to rebut Trump? Or does US v. Trump give Trump sort of the best of both worlds, where he can selectively introduce whatever official acts evidence is good for him, but not allow anything else to be introduced?
What do you think, Anna?
I think we have no idea. This is one of the questions Roger and I, from the very outset, when this opinion was handed down, were wondering, what does opening the door mean in the context of presidential immunity? I have no idea. If you think about immunity as a kind of jurisdictional issue, then it's that the court, just even if Trump wants to introduce official acts evidence, it may very well be that the court the idea is that the court doesn't have kind of power to hear that evidence, whether or not Trump wants to agree to it. At the same time, I think it seems like, very often in evidentiary rulings, there is this concept of opening the door. It seems like it would be really unfair to the prosecution if Trump was able to just introduce official acts evidence and then they don't have an opportunity to rebut. And there may very well be different official acts evidence that could be used to rebut whatever it is that Trump wants to introduce. So it raises a lot of complications, and a big reason for the complications that it raises is that Section 3C of the opinion, in which the court says you can't introduce official acts as evidence, even in a prosecution in which the conduct itself is unofficial. And this is one area in which it becomes really complicated, where there's all these questions about opening the door. Roger, what do you think?
Well, I agree. There's absolutely no way to know the answer. This is a brand new doctrine invented at about 10:29 a.m. July 1st. And I think that a defendant, the defendant ex-president, if he wants to use official acts evidence, can. He's a criminal defendant. I assume that would, and it's his protection that he would be waiving. And, if you were to analogize to privileges, of course, if you waive the privilege for one thing, you generally waive it for everything. I don't think that's how this would work. The big problem is that with immunity, you're no longer talking about fairness. You're no longer even talking about justice. You're saying there's something more important than justice. The whole thing about immunity is letting criminals go in this context. And so if it's unfair, the important thing is to make sure that our leaders can act decisively and boldly and without undue caution. And that's the price of having leaders like the Borgia family. We have some injustice, and that is how I read the ruling. So I don't know how to resolve this question.
All right, Jeremy, the floor is yours.
The button. Hi. So, in regard to the selective prosecution Trump's been claiming, the Department of Justice is usually pretty mum when talking about cases if they say anything, but they're still humans, so they can, enjoy their job. Maybe in this case, even have some schadenfreude when prosecuting someone like Trump. Can that go against them? If it finds out that they're actually enjoying prosecuting Trump, could that put wind in his sails for claiming selective prosecution?
So the bar for a selective prosecution claim is extremely high. Trump is throwing these motions around on a pretty breezy basis, as a lot of politicians do, by the way. When politicians get prosecuted, they like to claim that this is for political reasons, and the selective prosecution motion is a very good way of arguing everyone does it. They just came after me because I'm in the way of them getting you, right? It's a convenient motion for that purpose. It's a motion that essentially never succeeds. And so what do you need to show in order to prevail on you need to show more than schadenfreude, by the way. You need to show, since most people, as you point out, take a certain professional satisfaction in doing their jobs well, generally speaking, and of course, selectiveness in prosecution is the norm, not the exception. That's called prosecutorial discretion, right? And so to prevail on a vindictive prosecution, selective prosecution motion, you have to show much, much more than that something was merely an exercise in prosecutorial discretion. We chose to bring the case against Roger Parloff, not against Anna Bauer, though their conduct was similar, right? That is not a selective or vindictive prosecution case. A selective or vindictive prosecution case will generally involve, and again, I think there just aren't that many successful ones, but will generally involve showing that we made a decision to get Roger Parloff, and we made it usually with some suggestion of vindictiveness or corruption or without regard to the evidence. And then we found something that we could nail him on that, 100 people had done more egregiously, but we went after Roger because that was what we had pre-decided to do. So think about, some of the, some of the cases in which a sort of disfavored defendant is selected and prosecuted based on some very common thing. This is not one of those cases, and that's why none of these, I think including in Eileen Cannon's court, right, none of these motions have succeeded. So I don't think you would reach the question of the schadenfreude of the individuals, frankly, because you need to be so far beyond that as to, to prevail that wouldn't even be especially useful as evidence. Roger, what am I missing here?
No, I think that's right. Just to be clear, Judge Cameron didn't rule on the motion for selective and vindictive. And in fact, she seemed headed in the direction of granting some discovery, which in itself would have been, I think,
extraordinary.
The first.
All right. David asks, this is the penultimate question regarding presidential immunity. I forget where I'd heard this suggestion, but someone suggested that a president taking office could disclaim any immunity granted under the Supreme Court decision. I can see PR gains by a presidential candidate disclaiming immunity as part of a campaign. What would the effect of that be? Could such a disclaimer be subsequently revoked? Would such a disclaimer made as a candidate have any effect on once inaugurated, or would the disclaimer have to be made as president? So I don't think the premise here is accurate. I don't think you can stand up as a president and say, I disclaim immunity. According to the Supreme Court, you have immunity. Now, what you could do is if you were indicted despite having the immunity, you could decline to plead it. Anna's laughing at me.
Yeah, because no one in their right mind is going to do that when indicted.
Right. So I think if you imagine that some president gets up on Inauguration Day and says, my fellow Americans, I take the oath of office today. I don't believe in presidential immunity. I promise you that if indicted for official conduct, I will not plead immunity, and I will not object to anything being brought into evidence on the basis of presidential immunity. I suppose somebody could announce that they're going to do that. But here's the thing, as a prosecutor bound by the law would still never bring a case because the person is in fact immune. And so, it's like if a diplomat were to stand up and say, I'm going to go on a crime rampage, but I won't plead any immunity. He's still immune. I'm like, he might not plead it, but you still wouldn't bring the case on that basis. So that's my gut about it. I don't know if either of you have a different instinct. All right, last question from Andrew. This is a follow-up on the existential question, that Ben expounded on regarding the project of following how principles of presidential accountability. Not sure that sentence has an end, but okay. Why not have more focus on the January 6th civil proceedings against Trump, Blasingame, known by other names in lower courts, I think, while not posing a threat of depriving Trump of liberty or other rights? Civil tort judgments are, to an extent, a tried and true way of holding wrongdoers accountable for injuries to others. So answer, we've actually given a lot of attention to Blasingame and other cases. They're moving super, super slowly. So one reason we are not spending more time on them right now is that they're quietly percolating along in discovery, and you hear an occasional blurb as the percolator percolates. But there's actually not that much public going on in them. Anna.
Oh, yes. I was just going to say, I actually listened in on the Blasingame status conference earlier this week. There was one. It was actually, I called in on the public line instead of going to listen in court, and it was a remote proceeding, and it was actually quite hard to hear the judge because his internet connection was really bad.
Better or worse than yours right now?
I don't know, because I have no idea how my internet connection is being perceived by everyone else, but it was really bad, and the attorneys kept having to tell him, Judge, can you please change your internet connection because we can't hear you? But basically, Ben is correct in that things are moving slowly. It was basically They're still in the process of discovery. There are subpoenas that are out to various federal government agencies, and there are potential depositions that could happen later this month. And I believe where it ended is that they still want to try to wrap up, certain discovery matters in the next month or so. So things should be moving along as soon as there's a little bit more that's happened with the discovery. And I do expect that we will be following those developments as they happen.
I listened in as well. I think where it stands is that they're shooting for a discovery deadline of September 13th for immunity issues, and then there will be a summary judgment motion on immunity, and that will probably lead to an interlocutory appeal. So we are way down the road on the substance of these cases.
Life is short, civil litigation is long, and Wagner is longer still. We are going to leave it there. Roger Parloff from the Scott studio, Anna Bauer from the Grateful Dead room in her palatial mansion in Nevada. Look, as we always say on this show, Judge, could you please get a better internet connection? It's the slogan. We will be back next week. If you are watching this on YouTube, there are 270 of you right now, and each and every one of you should look within your souls and ask yourselves, is it time that I became a material supporter of Lawfare and joined the inner circle? Hint, in the inner circle, you get to ask questions, you get to play in the chat, which is really fun. We have great people in the chat. We have people who will answer your questions. We have people who will be nice to you and show you where you can get documents. It's really a cool group of people, and you can join. Just become a material supporter of Lawfare, which will help fund things like this show, which is not free to produce. So lawfaremedia.org/support. And that's where you can do it. You can also make a one-time contribution just on the little donate button there on YouTube. But figure out a way to support us, because we are doing this every week, which brings me to my final point. We will be back next week, by which time we will have that 48-page not so joint status report from the parties in front of Judge Chutkan. And, I'll eat crow for being wrong. See you next week.